Hello everyone, it's Sade here. Welcome back to the video updates. Today I'm going to cover a question that we received regarding mechanics liens. And of course, each state has its own laws regarding these types of liens. They are specific to contractors or builders, remodelers, people like that. And in Texas, the protection for those people was put together under Texas Constitution. So there are two different modes in which a contractor here in Texas can actually file a lien or claim or make a claim for mechanics lien against property. And different states have different laws that they've established to protect repairmen or contractors that work on homes, so that you don't give up your labor, time, and effort and your expertise and have a homeowner or a general contractor stiff you. So in order for them to be protected, each state put together some laws that allows them to file a lien against that particular property, even if it's a homestead. Here in Texas, the protections were put together by the legislators under the Texas Constitution, and it's Article 16, Section 37, if you're interested in looking it up. However, that section doesn't really go into details other than to say that the state can also put together some statutes to protect the contractors. So in Texas, we have the constitutional protections, but then we also have the statutory protections that were put in place, and that you'll find under the Texas Property Code Chapter 53. So you can look into it, but the property code, which is statutory, it's followed strictly by the courts, and so everything has to be done just so. And you'll see when you review that there's just a ton of requirements in that code, in that statute, and it's very easy for somebody to do something incorrectly or omit to do something that's required in order to perfect the lien. And when we talk about perfection, it just means that for it to be proper and for it to be enforceable. And so for the statutory ones, they do have to be filed. Certain notice requirements have to be followed, and the notice requirements vary depending on whether the contractor is the original contractor that had a contract with the homeowner or with the property owner if it's commercial property, or if it's somebody down the chain, such as a subcontractor, for instance. So in any case, as a subcontractor, if you are one and you're watching this, you do have rights under the Texas Property Code that allows you to ask questions, allows you to request documents from the general contractor or anybody else that's above you in the chain. So let's say that a general contractor is in charge of building a commercial building and hires a subcontractor to maybe put in the landscaping, in that community, and then the landscaping contractor then hires you as a subcontractor to help in a specific section of that development. So then you have two people ahead of you in the chain, and you have a right under Texas Property Code to request their contracts. So you'll request the landscaper's contract with the general contractor, and then from the general contractor you request to see their contract with the owner of the development. So you are allowed to do that, and they have 10 days to respond to give you the information that you requested. Of course, people don't give you all of the time, but it's good to protect yourself by at least asking, and make sure you have a record of the request by sending everything certified mail with return receipt requested, and also send by first class mail in case they reject or don't claim the certified mail. So if you do those things, it sets you up for being able to enforce a lien down the line. And then the next thing to look out for is that with the statutory ones, there are lots of requirements. So when you get to the point where you notice that you're not getting paid, or when you get to the point where you're starting to feel uncertain whether you will get paid for your effort or for your work or for the materials that you've provided, then of course you need to start talking to a lawyer. You should talk to a lawyer that's in construction law, because they know more about the notice requirements, and they can help you follow them strictly so that you don't lose your opportunity to have an enforceable lien in the future. So this should not be done by yourself, in my opinion, because the language is a little bit difficult to navigate, and it's not as clear if you haven't been in the legal field for a while. And so we always suggest that you consult with a lawyer and actually hire the lawyer to do all of the notices for you, and to also make sure that the final affidavit is filed into the property records. And you only need to file it in the county where that particular property is that you worked on. So that's the statutory part. And then the question that came up was, well, if there's a mechanic's lien there, is there an expiration date like any other lien, right? So yes, there is an expiration, but the expiration is not as to the lien itself. The expiration is as to the actionable part of the claim. So, there are statutes of limitations on different actions, such as if you have a debt that you have to collect from somebody, you're supposed to file your lawsuit within a certain amount of time. So with the mechanic's lien, the power that the mechanic's liens give to the contractors, according to the Texas law, is that they are able to file a lawsuit to enforce that lien, and the enforcement comes in the form of asking for a foreclosure. The options for the homeowner will be either to pay this contractor off and settle the debt, or the judge would find that the contractor can actually force a sale of that property. So it's a different type of foreclosure, but it still results in a sale of the property in order to then take money from the sale to pay the contractor's lien, the mechanic's lien. So that is actually the recourse that the contractors have under the mechanic's liens. Most of them don't go forward to actually file a lawsuit unless the amount is quite a large amount. And so what happens if the lawsuit is not filed? Does the mechanic's lien go away? So that's the question we're addressing in this video. The first part to know is, what is the statute of limitations in the first place? So if the property is commercial property, the statute of limitations, according to the statutory type of lien, is going to be either 1 year or 2 years. We'll have to know more about the type of project that it was and how the project ended or was abandoned in order to figure out whether it was supposed to be filed in 1 year or if it was supposed to be filed in 2 years. Okay, so that's for the commercial property. When it's a residential property and the mechanic's lien was filed under the statutory rules, for lack of a better term, then the contractor has 2 years to bring a lawsuit, 2 years from the time that the claim arises. And lawyers would argue about what time the claim arises, but it's a very safe bet to say that from the time you start sending your notices of non-payment, that is when the claim would arise typically. So you really should be filing your lawsuit 2 years from that time frame if it's a residential property. And if it's a commercial property, the lawyer will tell you whether you need to file the lawsuit within a year or within 2 years. So now what happens if the contractor fails to file the lawsuit within that 1 year or 2 years or whatever it is? Well, the contractor would then still have the lien against the property, right? It's still filed in the property record, so it's still sitting there. It's just that they have no right to force a sale. So the debt is still owed, technically speaking, but it's not going to be enforceable. So let's say that the homeowner then tries to sell that property and the title company finds that mechanic's lien that's from 6 years ago. The title companies would always try to get things to move quicker, and they'll try to get things to move quickly so that they can move forward with closing. That's their job. So the homeowner would then have to challenge the mechanic's lien, which might take 6 months or a year. So because people are trying to sell at the moment, they usually are pressured into settling the debt anyway. So they might be able to negotiate the debt down and then settle it just to be able to move forward with that closing. Even though they're no longer enforceable by law, they could still be collected. And so that's how that would work. But if you're the type of person that's not in a rush to sell your home or to sell your commercial property, then you could hire a lawyer to challenge that mechanic's lien to try to remove it if you don't have any time crunch that you're under. So that will be the effect. The contractor will lose the right to enforce it. Now, what about those that I talked about that arise under the Constitution of Texas here? So under the Constitution, it says that if the contractor had a direct contract with the owner of the property, that the contractor can then have a self-executing claim. And so the contractor can then have a mechanic's lien if they provided materials, labor, or did repairs on that property and they were not compensated for it. And under the Constitution, it's a self-executing type of claim. So it's not required that the contractor files all of these notices. It's not even required that the contractor files any affidavit at all. It's just by the contractor's own word and whatever documentation the contractor has. And they can go to court and try to make that claim and enforce a mechanic's lien. So the statute is very strict and it has a lot of requirements, and a lot of people follow the statute because they don't have a direct relationship with the owner of the property, so they do have to go by statute. But if you have a direct agreement with the owner of the property, then you could go without doing all those other things under the statutory scheme. And in the Constitution, it requires that all of the owners must have signed the contract. So you cannot have a contractor that worked on a home that's owned by husband and wife and only have the contract signed by the husband. It has to be signed by both husband and wife. So be very wary of that. So be very careful with that. Make sure all the owners are actually signing your contract from the get-go. And then you could potentially file an affidavit without needing to go through all the notices. As I said, you could file the affidavit of mechanic's lien inside the property records. It's best to file it, even though the Constitution does not require that. And under the Constitution, you have 4 years as opposed to 2 years to be able to bring your lawsuit. So let's say you worked on property in 2016 and the owners never paid you, or they paid you a little bit and they didn't pay the balance, then you could file an affidavit of mechanic's lien just stating what happened. You could attach documents if you like or not, but make sure to send them a copy if you can. It's not required, but it's best to do that, right? So you will do that, and then within 4 years, you would want to file a lawsuit asking to be paid or for the court to sell the property. And whenever it's a homestead, the state does not like to take people's homesteads away, but it does allow you to come and try to do a foreclosure even in that situation. But that's just because the Constitution really tries to protect contractors against, these shady homeowners that don't pay you. And that's what it's there for. So I hope that this video shed some light on the differences with the mechanic's liens, and as a property owner or a potential buyer, you would not really know whether it is something that has a 1-year statute of limitations, a 2-year statute of limitations, or a 4-year statute of limitations unless you speak with an attorney and do a consultation. You might be able to guess that it should have been a 1 or 2 year limitation period if it was commercial property that was involved. But otherwise, you don't really know, because if it was residential property, it could be 1 year, it could be 2 years, or it could be 4 years, depending on the set of circumstances and facts. So you should always consult with a lawyer in your state and ask these questions. The same thing if you're interested in buying that claim from the contractor. Maybe you're interested in purchasing the lien so that you can enforce it. So you should know all these things so that you don't go about buying bad claims or unenforceable claims. So this is my quick video for you for today, and I hope that it's giving you some insight into how some of these things work and how the mechanic's liens might be able to be challenged and when they might be able to be challenged, or maybe when they might have expired already. And if you have any other questions that you would like us to answer, remember you can drop a comment below and we'll try to cover that in future videos. And if you like this video, please give us a thumbs up. If you like the channel as a whole, remember to subscribe and hit that notification bell so that you can continue to get notices of our future videos. Thanks as always for watching, and I will talk to you next time.